She's sleeping. Hello,
Sleep.
we are live. This is attorney Vincent Davis, and this is The Secret, How to Fight CPS and Win. I'm joined by my co-host for today, Mr. Darren Guai, all the way from the state of Maine. Darren, how are you today?
I'm doing well, Mr. Davis. We're going to try this new technology thing out that we got. Got one of the new fandangle modem things here. We're going to try that out to get off that dial up.
You know, you just froze for like a second.
Oh, come on.
I swear.
Oh my gosh. Well, hopefully it was just maybe it was aren't you guys having a storm out there or something?
It hasn't reached us yet.
It hasn't come.
It's about to hit us in 3 or 4 hours.
Oh, Deidre must be outside trying to stake her house down or something, right?
Yeah. You know, I went to the store just to pick up a few things.
Oh, empty.
Everything was empty, and I'm like, what happened? And they said, oh, the storm. But the storm's only supposed to be here for 1 day.
Yeah, they do the same thing here. It's going to snow, and man, you go to the grocery store, people are murdering each other in line. It's crazy. Absolutely crazy.
Hold on. My cable company is calling me. Let me call.
Oh. It's about my internet.
They're warning about the possibilities of outages today. So good thing we're doing.
Yeah, good thing we're doing the show out there.
Yeah. So, you know, our guest that was scheduled today was someone from California. She's not answering the phone, and she didn't log in. So we confirmed yesterday at like 5:30, but I guess that was too soon to confirm for a Sunday morning on the day of our.
Well, confirming doesn't mean that they're actually gonna be there, does it?
Apparently not.
Right. I think that means that there's just maybe I'm gonna confirm that I'm gonna be there. Right. I'm pretty sure that there's nothing anymore that means 100% from anybody. I mean, honestly, like, I mean, even that with you and the law stuff, contracts, all that stuff, right? Like, no, that doesn't make sense. We can rescind our signature. You know, like no one even upholds their end of a contract deal anymore, right? Like you see that stuff.
Oh, absolutely. So let's make this a good show. Why don't you ask questions, and people watching can also post questions on one of the 8 social media sites we are simulcasting to. Yep. And let's take good use of this time and do a good, informative show for people. What would you like to do, Mr. Guai?
All right. How about we do this? We'll do something like this. We'll run down from start to finish. Top 3 things not to do when a caseworker comes to your door for the first time.
Open it. Number 1.
Yep.
Don't let her in. Number 2. Number 3, don't talk to her. Refer her to your attorney. Now, people, you know, I say this all the time, and people think I'm joking. I'm not joking. I can't tell you how many people call me and they'll say, oh, you know, I saw your videos, but I decided to talk to them anyway. And now I'm so sorry that I talked to them because they're using everything that I said and they're twisting it and they're using it to take the kids away. Right. Is that normal, Mr. Davis? Yeah, that's normal. I don't know how else to tell people, you know. Now, you have to talk to the social worker if they have a warrant. And even if they're accompanied by the police without a warrant, they're out of luck. I have in my office, when you open the door, it says, do not enter, come back when you have a warrant. Okay. Now, I've heard stories a lot of times where, you know, police are there and they kind of force their way in. And there's nothing you can do about that because, you know, they have guns and there's a lot of them. But if they don't have a warrant, you don't have to let them in.
What does a warrant look like? Like, what does, because I know that they'll come sometimes with like a preliminary protection order, or they'll come with these certain things. What does an actual warrant, like, what is the document that is to see?
It's a piece of white paper with typing on it. And it says court order, warrant, affidavit, something like that. And it's signed by a judge, you know, usually a judge who's on, you know, call to handle emergency warrants. And in Los Angeles, such a big city, big county, that they have judges, like 1 or 2 judges that are on call 24/7. they do a rotation, and I think that part of your gig as being a judge is you like 1 week in a month or something like that. Or on a Saturday night or Sunday, you have to be available to take calls for warrants.
Now, is there a way to verify those if they come with one, or should you verify? Or I mean, call your attorney, obviously, or whatever. Or do
Yeah,
you just
call
kind
your
of got
attorney, but generally, if it's a warrant signed by someone purporting to be a judge and it's handed to you by some law enforcement officer, it's pretty much a warrant, right?
right?
There's nothing you can do about it.
So they come, they take your kids. What's the first thing you do after that? I mean, obviously, call a lawyer, but what are the things that you do now to get yourself ready for the next hearing is the 72-hour, right? Or you guys call it the
We call it the detention hearing. It has to be
yes.
held within 48 to 72 hours. And
And
so
does
when
that
you
matter if it's a weekend or if it's anything, or does there need time constraints?
actually, I believe it's court hours or court days, but no time constraints. And if they don't hold it within that time period, there's no actual remedy within the juvenile court. Oh, instead of 3 days, it was 4. Oh, so sorry. Let's go on with the hearing.
So if they go further than that, that's a problem.
No, it's not.
Oh, okay. So they just have to have it within. Well, it's not a problem for them. For you, it is, because now you're just going longer and longer.
Right.
Now, what about visitation with your child when they first take them?
That's a good question. I and another lawyer were thinking about bringing a lawsuit against a certain county in California. The code actually says that you have to have at least one visitation between the detention and the detention hearing, the first hearing. And so many times that's violated. I'll talk to people. They just took my kid. When's the court date? Tomorrow. Have you had a visitation? No. The social worker said I can't visit.
Mm-hmm.
That's against the law. And unfortunately, when you go to a CPS court, juvenile court, it doesn't mean anything.
Right.
You can't do anything about it. There's no remedy. There is a remedy though if you want to sue them in the civil court, but that's not going to help you get your kid back right away. Every once in a while I get the legal the person who believes they know legal stuff, the legal genius, who tells me, okay, Mr. Davis, I want to hire you to do the lawsuit because that will make them give me my kid back. No, it won't.
Right.
And then I got to try to explain to them,
right.
Why it won't help. And then a lot of them, a lot of people get mad and think I don't know what I'm doing because I don't agree with the strategy that they somehow thought up,
Right.
the non-lawyer strategy that they somehow thought up. So
they read the common law books and these type of deals that they think still matter to the regular world that they don't, because
I haven't seen that book, but I can tell you that common law in California is a no-go because everything is statutory now. It's already a law has been made, and the statute takes over or takes precedence over the common law. Generally,
right.
Are there any common law concepts? Yes, but when it comes to the issue of them taking your kid, you getting the kid back, that's all statutory. Common law, there are no common law arguments. And I see
Right.
so many times people using, well, I heard on the internet from such and such who's not an attorney that if you make these common law arguments, you'll win. No, you won't. No, you won't.
See, people like to do that. Life, liberty, and the pursuit of happiness is their
Right.
their key. And I mean, I guess in essence, it seems like it's legit. But like you say, in the courtroom, they've already made law that turned to statutes, that turned to this, to turn to that. We've already voted. We've already voted the people in that voted that rule out. Essentially, is what what you're trying to say there. Like, it's right. So
it's like a snake oil that you can use that will cure all diseases.
right.
Common law is the snake oil that will solve every legal problem you have.
Mm-hmm.
And those who buy into that argument, it may be months before they realize that they went down the wrong path.
And at that point,
But
it's too late.
for those few months, they're like focused on it. And anybody that doesn't believe this or pursue this, they're, assholes, and they should be, never go to as a lawyer. I think I told a story one time where a guy hired me to do a case up north.
Yeah.
Right. And
Yeah.
he didn't mention anything about the common law arguments. And he hires me And he tells me after he hires me, and he pays me money, pays me a lot of money, as a matter of fact. And I think he purposely didn't tell me because he figured that once I got the money, that I would just keep the money and do anything he wanted to do, which
Right.
turned out to be false. So
Right.
he hires me, he tells me, "Hey, man, I bought this thing on the internet for $49.95, and you'll be a complete winner with these arguments." And I'm thinking, "Hey, man, I've been doing this over 30 years. What do you mean? I know what I'm doing." He goes, "No, but these are guaranteed winners." Now, somebody, a non-lawyer, had guaranteed him from some website that if he bought this product for $49.95, that he would win and get his kids back.
Right.
So I told him that that wasn't true. I told him that it wouldn't work. And if he wanted a refund, I'll give him, you get a refund right now, 100%. He said, "Yeah, give me my refund." And I said, "Okay, good luck. Here's your refund." And maybe 2 or 3 months later, he calls me and he says, "I hate to admit it, Mr. Davis, but you were right." I go, "What do you mean I was right?" He goes, "Well, I tried all of those arguments. I made the judge let me represent myself, right? And I made all the arguments." And he said, "They basically laughed at me in court." And he said, "I lost." And I said, "Yeah. You remember I told you that?" He said, "Yeah." He says, "You were right." He says, "But how can people get away with selling this on the internet for 49.95?" Everything on the internet is not true, and everything on the internet is not, some things are a scam.
The days of the Dewey Decimal System and checking things out for yourself at the local library are gone. If it says it online, it's true in most people's
Right,
eyes now. No one
right.
references it, no one nothing. So we got the kids. The kids have been taken. The 72-hour hearing doesn't go your way. Now what's
Right.
next?
Well, you know what? Here's a better question. What should I argue at the 72-hour hearing?
Okay, yes,
What should I
yes.
do at the 72-hour hearing to get the kids back?
Mm-hmm.
Now, I'm assuming that you're represented by an attorney, and that you and your attorney have strategized and come up with a plan. The main thing that you want to do is your attorney should do is argue the fact that you are not a risk to the children. And this is the important part, a lot of people forget, and that the social worker didn't provide you services to prevent taking of your child. And this actually happened to me a few years ago in front of a judge who I never thought would rule this way in my favor on this particular issue. It was a very close call about whether my client was a risk to the child at the very first hearing. The county's attorney and the minor's attorney made very good arguments why my client was a risk. I, on the other hand, and the father's attorney made very good arguments why my client wasn't a risk, and therefore the kid should go home today. You know what the tiebreaker was? The tiebreaker, and I didn't really argue this, the judge brought it up. The judge says, "Well, you know what? It's a close call. I'm going to go with Davis because there's nothing in the report that really shows that the social worker fulfilled the statutory requirement to offer services to prevent detention." And he says, "I believe there are services that we can give this mother to make sure that the kids aren't at risk pending the next court hearing." You know, I I
Wow.
literally almost fell over, you know, and I'm thinking, "Oh God, he's following the law."
Right. Imagine this. What is the percentages, would you say? Like if you go, you're a parent, this just happened, you're going into this hearing. What do you say honestly is like I came up with that stat the other day that they came out with that reunification is only works for 33%, like the people that go into it. What would you say when you go into the 72-hour hearing? What is the likelihood of your child coming home?
10%,
10%.
just an average. It depends on the case.
Yeah.
What kind of case is it? You know, but I would just say as a wild guess, 10%. Now, there's something that you can do to increase that percentage, and it's not done all the time. Sometimes it's not done for strategic purposes. Sometimes it's not done because nobody thought about it. and that is asking for what used to be called in California a Dennis H hearing. But what the statute says, I think it's a 319.1 hearing. It's basically where you get to put the social worker on the stand
Mhm.
and cross-examine her to prove that your client isn't a risk to the child. Generally, in a lot of counties in California, that's done within, I think it's like 2 or 3 days, and a lot of judges will do it the next day. And in some counties, if you ask for that, they'll bring the worker into the courtroom right then and there and
Oh
put her
wow.
on the stand. I don't know if they still do this, but there's one county, San Diego, that used to require the social worker to show up to the hearing because they're not required to show up. Um, and to show up at every hearing in case the judge
Of
or the
course.
attorneys will cross-examine her, so there would be no delay, which I
Okay.
always thought was a good idea.
Well, I
So
would think that you would always want to question the social worker, wouldn't you? Isn't that part of your strategy? Or unless you know that it's got to be hard where because you're the attorney, so you're privy. Most cases, your clients are telling you the truth, so you might know a certain degree of things that you're like, whoa, we need to ask the social worker any questions because we know where we're
right.
at.
you remember
So,
I said you remember I said there are strategic reasons
mhm,
not to do it
right,
sometimes, depending on the case. All
right,
right. So you just don't, you don't want to have a hearing when there's one that's not needed. I took over a case in Southern California not too long ago, and I wasn't the attorney at the 72-hour hearing. The attorney was a very experienced family law and divorce attorney, and he requested a hearing, a contested hearing on the detention. And I guess they did it that day, like in the afternoon. And then one of the bigger mistakes you make, which he made, is he put the client on the stand and let everybody on the case, including the judge, ask questions.
wow,
She did such a bad job of testifying, right? Because she wasn't prepared. She didn't know anything was going on.
right.
That the judge told me when I came onto the case, a couple weeks later, Mr. Davis, you weren't here when we had the contested detention hearing and your client testified. And I'm thinking, why would my client testify at the detention hearing? And I guess she kind of looked at me. She said, because her attorney wanted her to testify. And I'm thinking, okay, well, maybe the attorney didn't have the experience, you know, strategically in these situations. Well, after the hearing, this judge kind of made really negative findings against the client and some of her biggest supporters who were witnesses that were going to be witnesses in the future.
So now you
So,
just nullified them.
well, now you have to work even harder. The mountain is even harder to climb to bring her back into, getting the kids back. So you don't want to have a hearing sometimes
Right,
because if they're going to do it that day, your client's not prepared. You're not really prepared. You just got the paperwork that day, you know?
right. Now that hearing can be used. Anything that's in that hearing can be used from there on out, right? From throughout your case.
Absolutely. Absolutely.
So that's why one of the proceed with caution type rules too, right? You don't
Right.
want anything to spill the beans or whatever that you automatically are facing down the road. Now you
Right.
get out of there. You've asked the questions. You've looked at what is next. So like in Maine, I'll give you a for instance because you guys say all this stuff is different. In Maine, you go from there, then you go to what they call jeopardy. Then you get found in jeopardy. Then you go to a couple of judicial reviews, and then it's on to the TPR if you haven't figured out what's going on. That's how Maine lays it down right there. You get a six
Well,
month to 12 month.
in California, before you get to the 12 month,
Yep.
you have something called the jurisdictional and dispositional hearing. And I bet that's what you call the Jeopardy hearing in Maine.
Okay. Where
And
you go
at
in,
that,
they find out what
well,
you did, what the
yeah,
accusations are.
at the jurisdictional hearing, the social worker has to prove by a preponderance of evidence that you're a
Mhm.
risk to the child and that the allegations, or at least some of the allegations, are true. If you prove that the allegations are not true, the case is dismissed. If they
Mhm.
prove that part of the allegations are true or all of the allegations, you move immediately in most courts, not all, to what's called the disposition hearing. And the
Okay.
disposition hearing is one of the most important, not one, is the most important hearing in the whole juvenile dependency process. It's where the social worker must prove by clear and convincing evidence that you are a substantial danger and
Mm.
that there are no less restrictive alternatives other than keeping your kid in foster care.
Yeah,
Okay,
see,
so now if you think about it, it's hard to prove, in my mind, that you are a substantial danger to a child by clear and convincing evidence. That's
hmm
really hard to prove. However, it's taken for granted, and people agree to it or find it all the time. There are a lot of things that you can do to mitigate that substantial danger finding. Let's say you have a drug case. Between that date and the original detention, you can show the judge, "Hey, judge, I've taken 10 drug tests. They're all clean. I'm no
hmm
longer a substantial danger." The 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 judgment of whether you're a substantial danger happens on the day of the trial, not on the day when they took the kid away from you. You see,
Okay.
you could be a substantial danger on that first day, but between that date and week 4 or 6, you could have done a lot of things to eliminate that substantial
Right.
danger.
So
You may
as
have
of
just
now,
Yeah, as of right now when you're in the stand. So you could have done drug testing, you could have taken your parenting class, you gotta get enrolled in anger management, you could have gotten enrolled in domestic violence, blah, 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 blah,
right?
right? So that substantial danger is gone, okay? And if you show that there is not a substantial danger, they have to return the kids back.
Now that
But
seems to be knowing you and seeing you. That seems to be like where I would think that you try to have the most impact is at that point in time, right? Like
yeah,
that's where you try to pull out all your guns.
right, because you never get that type of advantage statutorily in one of these hearings ever again. You'll
Right.
never see that again. And if you lose that, your case kind of goes to the left, and it's very hard to recover from that.
Right.
At the 6-month hearing, if you did all your services and blah, 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 you've already been found to be a substantial danger to the kid. Your participation in the 6-month program and your progress or your internalization of those programs, it better be super high,
Right.
super high. A lot of people tell me, oh, they told me if I just agree with everything and have the kids in foster care, I can get them back in 6 months. That's a bad, bad plan. That's a bad
Right.
strategy. Okay. It might be applicable in some cases, but in most cases, it's a bad strategy for you to say, okay, put my kids in foster care for next 6 months. I'll go do the programs. Because inevitably, what happens is we come back in 6 months. Mr. Davis, I did everything, but now the lady won't give me the kids back. Yeah, that's par for the course, my friend.
Right.
Par for the course. Because either you missed a class or you tested dirty ones or
Right.
you missed a test, or, and here's the big one, you did everything, but the social worker believes you didn't get anything out of it. You didn't
Yeah.
internalize. So
hmm
therefore, it's like you didn't do it at all.
Right.
So we're
It
not
was
gonna give you kids back.
6 months.
We'll give you another 6 months, and now we're at a year, right? And then this is what really happens in my mind. At the year date, if the kid's doing really well in the foster parent's home, it doesn't matter what you did.
Right.
They're going to
They
recommend the
attach
kid not
themselves.
return because of the attachment, emotional, physical, psychological bond between the kid and the foster parent. Now, that's not the law, by the way. The law is if you've done everything and you've internalized it, you got something out of it, you're supposed to get your kid back. I
Right.
don't care if the kid's calling the foster mother mommy and daddy. It doesn't matter.
Right.
That's my opinion anyway.
Right.
I'm sure that there
Well,
are people that disagree
because it
with it.
didn't matter. It didn't matter when they ripped them right out of your house to begin with. Like that didn't. So now what you're saying here is, do you think the bonding study that you always promote and that you talk about in your book, the bonding study should be done almost right away? Correct? Is that what you're saying that should be done?
That's a very good strategy. Yes, but that rarely comes up. That rarely people think about it. However, I'm doing a case and it's on, I think, tomorrow in up north in California, where we're in the middle of the case, like the first 6-month date. The social worker is asking for a bonding study to show there's no bond
Oh,
between the parent and the child.
wow.
They're kind of like reversing it on us, which
Hey,
is actually a really good strategy, legal strategy on their point. They're
right,
real
because
good,
if she wins that from the beginning, then they have no case, really, right?
right?
Mrs. Diaz just said, "What about testimony from a caseworker that's a trainee?" I guess that would be like, how do you look at the testimony, or is it valid? What about testimony from a social worker who is a trainee?
It's valid. It might be easier for you to cross-examine a trainee, the fact that they don't have any experience, the fact that they don't, maybe they just got out of college, the fact that they don't, this is their first case or something like that. But, they still can testify, at least in California. Social worker trainees can be witnesses against
Well,
you.
right, and in California, right? Didn't we discover that they don't even have to be a licensed caseworker, right? Isn't that correct?
Well, don't have to be a licensed social worker.
Social worker, right? Okay.
Right. I don't know about other states. Apparently in Maine, you have to be licensed, but not in California.
Yeah, in Maine, you have to be at least LCSW something. It's the letter, but it's a training. They have 4 years to complete, but they are some sort of a licensing. I guess another caseworker vouches for them and oversees their works or whatever they do. Anyway, so all right, so now we've gone to the 6 month hearing, right? That's where we're at with you.
Right. So at the 6 month hearing, the social worker, it's kind of turned on its head in the way the law states and in the way it's actually applied. At the 6 month hearing, the judge must return the kids to you unless the social worker proves that you're a substantial risk to the child. And the law also says that it's almost automatic that you're a substantial risk if you didn't take and successfully complete the programs.
Okay. Now, do you have to do programs that the social worker says or what the judge has ordered in the previous hearings?
It goes different, by way of the judge and by way
Okay.
of your attorney. The law actually says you have to do what the judge ordered at the previous hearing. That's what the law
Okay.
says. Typically, what happens in a lot of states and a lot of counties, even in California, at the 4 month mark, the social worker says, "Oh, you know what, Darren, I think you need to do blah, blah, blah." Now, the question becomes, do you have to do that? And number two, if you don't, will it be used against you at the 6 month hearing? And, I've seen it go both ways. I've seen it go both ways. What happens more usual than not is they bring it up at the 6 month hearing and they decide not to return the kids to you. And the judge orders that additional counseling or testing or whatever it is to be done by you in the next 6 month hearing. That happens a lot.
Right.
And I think the law in California is the social worker can do that. Now, at the time
Oh,
of the hearing, unless you have a trial, you can prove at a contested 6 month hearing that the social worker who wants you now to do drug testing, that's bullshit, and you shouldn't be have to do it. But you
right.
got to have a trial, and you got to present evidence on why.
Because nothing can change unless a judge orders it, correct?
Correct. But this is what usually happens. Okay, and I want you to notice this very slight difference, but it's a huge difference in reality. When you have a hearing, say you have your 6 month hearing, okay? If you don't do a contested hearing, the judge, more likely than not, is going to go with the social worker. The only way that you can change the judge's mind is if you present evidence. How do you present evidence? You have exhibits, you have witnesses. At a lot of 6 month hearings, what happens is the attorneys just argue it. My argument at a 6 month hearing is not evidence. Judge must make a decision based upon the evidence. Okay?
Oh, okay. Yeah.
The evidence before it. So sometimes you have an argument, and occasionally, a parent attorney might win one of those arguments, but generally not.
Evidence. Okay. I see.
All right, next question, sir.
So, well, I mean, let's see. I'll read these. I don't want anybody to get missed out on here. What about when at each hearing they find there's a high probability that your child will be returned to you?
What about it? It
Right,
means nothing.
right,
What about it? You didn't get them back.
right. The probability was, and you didn't meet the probability, I guess, right?
Yeah.
So
So
we get a
there.
6 month hearing.
By the way, I should be fair.
Mhm.
At the 6 month hearing, that finding is important because you get another 6 month reunification. You
Right,
get another 6 months of not being with your child instead of them terminating reunification and setting, a parental rights termination hearing in 120 days. Okay, so
okay,
it does mean something, but in the grand scheme of things, you're not getting the kid back. That's what it
right,
means. You might
right.
not get the kid back for another 6 months.
So that being said, we lose at the 6 month hearing. We do what now moving forward, and what's the process from there now? Because now we're in a whole different game. Because now we're losing
Well,
our
you have
we're abandoning, we're losing our time with our kid, the bonds, everything. We got a lot happening here.
well, you wait for the 12 month hearing,
Right.
and at the 12 month hearing, it's basically identical to the 6 month hearing. You get the child back unless the social worker proves you're a substantial risk to the child. Not doing the programs, not successfully completing them, testing dirty, will get you finding by most judges that you're not successfully completing the program, and therefore you don't get the kid back. And that happens at the 12 month hearing.
Okay.
If the social worker doesn't prove that, the child's supposed to be returned to you.
Now, are there things? What are so we obviously so we failed the 6 month hearing, we lose there. Now the judge orders new stuff, or are we continuing to work on things? What are the things that we need to work on now from 6 to 12 months that we weren't paying attention to up till the 6 month period?
The same case plan plus any new requirements that have put on your back.
Okay.
For example, they might have, for the first 6 months, they said, Darren, you have to do parenting, you have to do individual counseling, you have to do domestic violence counseling. And then at the 6 month hearing, they say, oh, we're going to add something, Darren. We need you to start drug testing once a week, randomly.
Okay.
Like, why is that? The social worker thinks it's a good idea. Or
Right.
they really have evidence that people have seen you under the influence, or you got arrested for a DUI or something like that to indicate you have some type of substance abuse problem, and they may try to add that requirement on. For it not to be added on, you and your attorney again must have a trial, must present evidence of why it shouldn't be. Okay.
Yeah. Now, side note here, do you contest all of these hearings if they don't go in your favor? Do you appeal? You try to, file for an appeal in all of these situations? Because I know we heard at the seminar, I don't remember which attorney it was, but one of them was like, "Listen, every time you lose, you appeal that decision. Always appeal your decisions." Is that one of your cons? Is that one of your strategies too, or do you?
No, that's not one of my strategies because appealing is all strategic. You might think that it's just right there, but the appealing should be applying strategically to the entire case.
Okay.
Okay, so it's on a case by case basis. Um, there are some things that generally you appeal. For example, if you lose the disposition hearing, where it was such a high burden for them to prove against you, and it was a close call, you might want to appeal that. If
Okay.
they terminate, your family reunification services, you probably always want to file a writ or an appeal on that.
Okay.
And in California, it's a special type of writ, not an appeal. And if they
Okay.
terminate your parental rights, you probably want to file an appeal on that.
Okay.
But one of the things the court doesn't want you to do, and that's the Court of Appeals, is file what they call a frivolous appeal.
Frivolous.
Right. But
Okay.
um, the frivolous in my mind is, hey, Darren, they asked you to do four things. You never did anything. You never visited the kid. We don't have any basis to file an appeal,
Right.
right? Versus Darren did everything, and the social worker is just saying that he didn't do enough.
Right.
Oh, we have to appeal that.
Understood.
Right.
Right.
Everything. What does Lloyd Christmas say?
says, Attorney Davis, how would you go about requesting the application for subpoena warrant for medical records from the sheriff's department in California?
Okay, Lloyd, first of all, your question is doesn't make sense. You don't subpoena medical records from the sheriff's department. You subpoena medical records from the doctor and or hospital. Okay, and you have to do it in California by way of something called a subpoena ducis tecum, an SDT. All right, and you would want to talk to your lawyer about how to do an SDT, because it's a little bit more than just a regular subpoena. There's actually some declarations you have to fill out. There's a form you have to fill out to get business records, in this case, medical records, brought to court by the custodian of record.
Okay. I wonder, I know the only other part of that Lloyd's question that maybe if he's not going to be right is maybe is he talking about was he in jail and he had medical records in the facility and that's why the sheriff's department had his medical records?
Oh, maybe so. I don't know.
I don't know. But if that was the case, how would you go about getting your medical records out of a jail?
You would subpoena the custodian of record, or the doctor who treated you, to get the medical records.
Okay.
Okay. Every business, every entity some governmental entity has something called a custodian of records. And that's the person who keeps all the records. All right.
Okay.
And whenever they're subpoenaed from the custodian has to go find them and bring them to court.
I see. Okay.
That's how it works in California and probably most jurisdictions.
Okay. All right. So we're at the 12-month. Unfortunately, there's Misty. So what if a judge orders testing through a certain company, but the only way you can do it is through CPS referral, and they refuse to do the referral?
Okay, so what if if they refuse to do the referral and the judge ordered you to do it, which you and your attorney have to go back and tell the judge, hey, judge, I'm trying to test. They won't make the referral, and therefore they're going to try to use that against me for testing dirty or no-shows. So, hey, tell them to give the referral right away. In the interim, Misty, what I've done in some cases is I've sent my clients to a local drug testing facility to take tests pending the social worker getting on her job and making the referral. I once did a case. This was a very odd situation. I won't get into all the facts, but I once had a client, and fortunately enough, she could afford this. I once had a client go to a drug testing facility and take a drug test every day for
Wow.
about 2 months,
Holy
uh,
smokes.
not Saturdays and Sundays. And then right before the court hearing, about a week or two before the court hearing, I had her take a hair follicle test
Whoa.
because the social worker was making wild accusations that she was a drug addict and blah, 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 blah. And, if you're an addict, let's face it, you're not using drugs once every month
Right.
or every 2 weeks. You're
Right.
using
You're
drugs.
surviving. Right. You're surviving.
I wanted to prove to the judge that she wasn't a drug addict and whatever the social worker was saying was false. Because the social worker had talked to people in the neighborhood who made comments about her and was
Right.
acting on those comments as if she were a drug addict, and she wasn't.
Right.
I mean, whenever I saw her in court or at my office, she seemed normal,
Right.
She didn't seem under the influence at all. So she started testing and she did the hair follicle test. And you know what? Every one of those tests and the hair follicle came back clean.
No kidding.
So, you know, the comment from the court was, well, how doesn't look like she's a drug addict,
Right.
right? And she was holding down a full-time job that she, worked 10 hours a day on. I mean, how could she be a drug addict?
Right.
Even a functional drug addict.
A functioning one. Right. Correct.
Yeah.
Because there's
And
still a certain degree.
that's gonna be hard to do.
Right.
And in that case, just like Misty's case, the social worker didn't want to set up everything. Took them a long time to set it up. And when they finally set it up, like maybe 4 or 5 weeks before court, so I had my client test there for the social worker and test it still at the facility she was going to. She was able to work out some type of, deal because she was taking so many tests that they weren't going to charge her the regular $100 per test. I think they only charged her
Right.
like 70. $75, but you got a discount because she was testing
Right.
every day.
Right. All right.
And if I remember correctly, it was at the same facility the social worker was sending her to.
Wow.
So, they couldn't say, oh, that's a, false or fraudulent drug testing scheme.
Right. It was still upheld by them. Right.
Right.
What about all right, so we're at 12 months, the review, whatever they call it, we lose, unfortunately. Now what? We're in deep chemistry.
In California, and I bet it's like this in your state, Darren, then you have to file. What happens is generally they terminate your family reunification services, okay, which is different from the termination of your parental rights.
Right.
Termination of your family reunification services, the first thing you should do in California within, I think the time period is 7 days, but I have to check that. You should file a writ. There's a special writ to say, hey, I want to appeal this decision.
Okay.
And when you appeal it, the case goes on. It's set for 120 days out for what they call a selection and implementation hearing pursuant to 366.26, where they will terminate your parental rights.
Okay.
So in the interim, you do that appeal.
Okay.
Occasionally, I get parents or hear about parents who win that appeal, for some reason.
All right. Now, are all of these points now from 6 months and beyond? Are all of these? Are some of? Is the chance of bringing your kid home alive in every one of these hearings when you go to them?
Yes.
So should that be a question that your attorneys are asking every time that you go to these hearings? Or, Your Honor, I would like the return of the children.
If you have the evidence.
Okay.
But let me give you an example. Sometimes what happens, and it's case by case basis. Sometimes you don't have the evidence to bring them home, but you have evidence to get more family reunification services. Okay. So you don't want to lose credibility by asking for return prematurely. If you ask for return and then ask for more FR, the judge will say, you're being an idiot because there's no way I can return the kids today. But, had you just asked for FR, I see you more credible. And, so there's strategic reasons to do it.
Right.
I did a case recently with Art LaSalenta. He had one parent, I had the other, and we went to trial. And we were able to win the most important part of the trial, which means they were going to get family reunification services. And it was our plan just to ask for family reunification services. But the judge did an interesting thing. The judge bifurcated the jurisdictional and the dispositional hearing. So when we go to the last hearing, we hear the ruling. We now go from we just want reunification services to send the kids home.
Right.
Send the kids home, which was different from just give us family reunification services.
Right.
Okay. So now we're going to trial at the dispo and we want the kid back.
Okay.
Okay. So, strategies change depending on judges' rulings.
Right.
In a case, their rulings evidentiary, things change and change and change.
So that would be after the 12-month, then you repealed that, then you said, bring the kids home is where we'll be at there.
Well, we're going to have a trial on whether the kids can be returned to the home.
Okay. And then
it was vastly different from our position on the trial.
More services. Right.
Right. That's a big
So
difference.
you were just originally asking for more time to work on these problems, but the way the chips fell, you were like, no. They've already said this, so let's get the kids home then.
Right. So one of the I think one of the county's attorneys said to Art, I thought you just wanted FR, family reunification services. And my response is, well, that was true. But now we have favorable ruling. We're going for the cutthroat, right?
Right.
It's home based upon the judge's ruling.
Yep. And then from that now, because I know we're getting close on the time, I'm trying to get us through like this whole process here. Mm-hmm. What do we go from that now? We go, say in your situation, you didn't win that hearing. So now they go to terminating your rights?
No, so yeah, they're gonna. If you didn't win the 12-month hearing, generally speaking, you could ask actually for another 6 months.
Okay.
And little known fact, you can ask for another 6 months to 24 months.
Okay.
We don't have to get into the details of that right now, but assuming that it's a 12-month hearing and you didn't
Yep.
get the kid back, what the court is going to do is set a hearing pursuant to 366.26, the selection and implementation hearing, where they're going to try to terminate your rights. And that's in 120 days or more.
Okay.
Okay. During that time period of the 120 days, even if you're appealing the last hearing, you and your attorney should sit down and come up with a strategy to turn this thing around.
Right.
Now, there are certain strategies you can implement. You can implement the 388, okay? And you can ask for the kid to be returned, or you can ask for more family reunification services, okay?
Okay.
Now, don't forget, you got to have the facts to back this up. And there's
Right.
law.
You can't just ask. You can't just ask to try to buy
Right,
time.
right. Or you can get the bonding study that you might have to use at the time of the 2-6 hearing. But also, and I saw this recently, where an attorney used an early bonding study to file with his 388 to give the judge more evidence that there should be more reunification services, and we should take this termination hearing, just erase it from the calendar, which I thought was a brilliant strategy.
Yeah.
It's a brilliant strategy. If the report comes back for you and it's good, like,
Right.
oh,
Right.
this on, and then versus the psychologist saying the kid doesn't even know the mother,
Right.
you know,
Right.
and that's where sometimes you shoot yourself in the head.
Oh God, Tim, why did you do that? Right.
So
So,
we're
yeah, so we're at the 12-month, then we go to they've stopped the services, right? They decide whether or not they are going to continue on, and then it goes to your termination of rights, right?
correct.
Okay.
Mhm.
Is
And
TS
then at the termination of parental rights, if your kid is 12 and over and doesn't want to be terminated, your parental rights terminated, they can't do it. Otherwise, you have to prove that your relationship with the child is so strong that it would be detrimental to the child, not to you, to the child, that it would be detrimental to lose your parental rights, which, by the way, is a hard thing to do in most cases. Because in most cases, you had this young kid, 1 year old, been removed from your home 1 or 2 years. You rarely visit, or you only get to visit once or twice a month. How are you gonna prove that? There's something
right.
that a couple of years ago I realized, and I always make it a point. When you lose your family reunification services at the 12-month hearing, it is standard operating procedure, but it's not the law. Standard operating procedure for the social worker to cut your twice a week visits down to once every other week or once a month. And the reason why they do that is not only financially, but saves them money, but it also prevents you from proving that you have a
Yeah.
relationship with the child 120 days from now, that it would be detrimental to the child for your rights to be terminated. If you go from 2 times a week to once a month, you're not going to be able to prove hardly any relationship at the termination hearing. So you're going to lose automatically. So
Right.
if that happens, you got to strongly object. You got to make that part of your appeal. You got to tell the judge, hey, look, this is what they're doing, judge. Because you didn't just go from visiting the kid twice a week where the kid enjoyed the visits to all of a sudden your visits are hurting the kid. That
Right.
didn't happen because you lost your family reunification services.
Right.
Yeah. So the argument is that well, since you lost your family reunification services and visitation is theoretically part of family reunification, you shouldn't have as much visits as you had before.
Right.
And that's, in my opinion, my humble opinion, that's not the law. So that's something that you should be addressing with your attorney. Now, if you go to the 2-6 hearing, the selection and implementation hearing, and you've lost your 388, you've lost your bonding study, and you lose your parental rights, tell your attorney, file notice of appeal.
Mhm.
In California, you have 60 days. I don't know what you have in other states, but find out the time limit. And a lot of times, what a good practice is is if you lose, you go right to the clerk's office,
Yep.
you get the form, you fill it out, and
Right.
you serve it right then and there, file it right then and there. Okay.
All right. Yep.
All right.
So
Those
that
are
pretty much brings us in, brings us
yeah.
to the end.
That was a good overview, Mr. Guy.
Yeah.
So the more and more you hear about the overview, you can like focus in on
Well, that's
issues and important things.
that's the thing. I hear a lot of people, when been doing this with you enough, like where they're stuck in the section of where they are at this piece, and they're looking for here, but you really need to be focusing on where you guys are right here.
Right.
Don't worry about a month. Don't worry about this. So I think that's why it's good that we do this from time to time. That way people cock them back and be like, hey, focus, because focus is the key to all of this.
Yeah.
Don't worry about this when you need to be here. Like be here. So I think that's good that we do this from time to time, so people realize, all right, well, we can. They don't get lost, because listening to what you guys have to go through and in comparison to what we deal with up here, I'm like, what the hell are these guys even doing? You got so many. Now, whether or not I was shanghaied and I didn't get these opportunities, I don't know. But, like there's definitely a lot of pieces to what you guys do out in California that's either, like I said, not available here, or we don't do, or whatever. So I think it's good for everybody to hear, so they don't get lost in their system and
Right. From what I know about your case, and we've talked about it occasionally here and there,
yeah,
the way you got shanghaied was not how you think. The way you got shanghaied was they gave you the hearings. What happened on your case was they didn't tell you the importance or the real issues at that hearing. So
right,
your focus was over here, and the focus you should have had should have been over here.
right,
So you were shanghaied in that part because you didn't really understand. As you look back on it now, after hanging out with me all these shows, you
right,
realize, oh my God, I should have done this, or I should have done that, or I should have told my
right,
attorney this.
yeah,
That's they call it in the law issue spotting. Okay, in law school, issue spotting. You know, you don't have to know the law; you just have to be able to issue spot. And you need to
okay,
know if this is an issue. Let's find out the law and let's find out how to win it in court with evidence and
right,
witnesses. That's what you didn't have. And what happens is a lot of parents are in that same situation. I hear it all the time, every day, 7 days a week,
right,
365 a year. They know something. Sometimes, most of the time, they don't know what even is going on. But
right,
when they do know what's going on, they don't know the issues to bring up and
right,
how to win
yep,
that. And that's, people just think, let's be fair. I'm the parent. I should get the kid back. And therefore I should win. And
right,
that's not going to happen. That's not going to, in 999 cases out of 1,000, that's not going to happen.
right,
Have I ever seen it happen? Yeah, I see it. Less than 1% of the time.
right,
The other percent, the people that are winning, know the issues, know where they are in the case, and have evidence. Have,
right,
as our missing co-host said, I have bullets in my gun. I have arrows in my quiver as a lawyer that I can use. I
right,
have evidence. Sometimes client wants me to go with no evidence and still expects me to win the case. Oh yeah, Mr.
right,
Davis, I didn't do the drug testing. Screw that. I don't agree with it. I don't like it.
right,
Okay, so you just send me to war with no bullets.
right,
How's that going to turn out?
right.
Not
That's
very,
really
not very, yeah. So I'm going to tell you what bullets you can give me, what arrows in the quiver you can give me, if you decide to do it. Okay, but I have even clients today that have hired me. I'm thinking of one case in particular. I keep telling the parent, boom, 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 and I keep getting, basically yelled at and cussed out. And then we go to court, and if we don't win, it's like, oh, it's your fault, Davis.
right. And you're
And
like,
I'm
no,
I'm thinking to myself, well, I told you I needed those arrows. I
right,
told you I needed those bullets for my gun, but you didn't give them to me because you had a personal problem with what the orders are, which were made far before me. I even got involved in
right,
the case.
yeah,
See earlier I said disposition hearing, most important case in in the the picture. At the disposition hearing, they determine what kind of case and services you're going to have to be ordered to do. Did your attorney allow them to argue the fact that since it's not a drug case, you don't have to do drug testing? Did your attorney argue that it's not a sex abuse case, so you don't have to do sex abuse counseling? Did your
Right.
attorney argue that, hey, it wasn't a DV case, you shouldn't have to do, the 12 months of DV counseling? I don't know. I wasn't there. Couldn't tell you.
Right.
But that's why that hearing early on sets
Right.
the tone for the rest of the case.
Hmm. And that's issue spotting.
Issue spotting. When you
Yep.
go to law school, your first year of law school is going to be focused on issue spotting. Because if you don't even know what the issue is,
Right.
you, you surely won't know what the law is. But
Right.
if you know what the issue is, you can go figure out what the law is.
Right. It could be a magnitude of things if you don't understand what you're looking at. So you could be
Correct.
arguing 12 things when in real reality, it's this one thing that you're supposed to be focusing on and you're not,
Or,
and you're missing it, or
or,
you could beat this.
or it could be 12 things and you don't even know it, so you didn't argue anything,
Right.
which is typically the situation. Oh, there's a
Yep.
lot of issues. I didn't know those were issues, and you never bring evidence forth.
Yep.
So that's the danger. Alrighty, sir.
All right, Mr.
We're way
Davis.
past the time.
Nice.
Thank you for joining me this morning, and we will be on tomorrow at 7 p.m. Pacific, same channels as today. All right.
All righty,
Have a
Mr.
good
Davis.
have a good Sunday. Bye bye.
See you. Bye bye.